Ladies and gentlemen, welcome to tonight's Board of Appeals hearing. Before we begin, let me introduce some members of town government that act as advisors. Assistant Planning Director. To his left is John Bongino, Town Building Director. Now let me tell you why you're here tonight. New York State statute requires that any town that adopts zoning must also have a Board of Appeals to act as a relief valve so that those persons aggrieved by strict application of the zoning ordinance can seek relief without the expense of going to court. Town board can give Board of Appeals additional powers such as special exception approval, site plan approval. In Smithtown, the town board has given this board authority regarding certificate of existing use and some special exception applications. The most common kind of application before the board are area variances. Area variances deal with dimensions such as lot area, frontage, height, setback, and parking spaces. New York State statute mandates that the board must consider the following 5 criteria in area variances. When you come to the podium to present your application, you need to address these 5 areas. They're posted for you. Number 1, whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created. Number 2, whether the applicant has other feasible alternatives. Number 3, whether the variance is substantial. Number 4, whether the adverse impact on the environment will be created. And number 5, whether the alleged difficulty is self-created. The statute requires the board to balance the interest of the applicant and those of the neighborhood or community. This statute further requires that the board shall grant the minimum variance necessary and adequate, and at the same time, preserve and protect the character of the neighborhood and the health, safety, and welfare of the community. The board has the power to impose reasonable conditions for granting variances. Special exception applications are different than area variance. When we have a special exception application before us, I will explain the different criteria. Regarding procedure, cases will be called in order they are advertised. When your case is called, please come forward, submit your affidavits and mailing receipts to Mr. Flynn, and then you will be sworn in the podium and will be given the opportunity to explain to this board why you need the variance. After the applicant is done speaking, all interested parties will be given one opportunity and only one opportunity to be heard. So please organize your thoughts, keep your remarks factual that are related to the case. Then I will ask the applicant to come back to the podium to answer your concerns. The board will then close the case and reserve decision. After all the hearings are closed, the board will review the cases and decide some of them. Others will be reviewed at a later date. There are 3 ways to find out the results of the case. You can wait until after the public hearing, but there's no guarantee that the board will act on your case tonight. Number 2, you can call the planning department tomorrow afternoon. Number 3, applicants can wait and be notified by mail. We do have some adjournments. First adjournment is case 1-15880, General Properties. It has been adjourned to May 10th. Next case is case 1-16355, Margaret Schercher. That has been adjourned to May 24th. And the last case that's adjourned is case 16391, Brian and Elizabeth Robinson. That has been adjourned to May 24th. Mr. Tramarco.
This afternoon. I don't know where he is, to be honest with you. So I'm going to need a short adjournment. He has some documentary evidence. I think that's the reason why you opened the case.
Do you believe he'll be here tonight?
I don't think so.
I don't either.
Okay. So maybe you know something I don't know, but we just need a short adjournment.
Okay. May 10th? That's the next meeting.
The one after that would be?
The 24th.
Yeah. Thank you.
Okay. So case 1-16200, Vendetta Vita and Mary Appalaro will be adjourned to May 24th.
In reference to the general property on May,
10th.
May 10th, can that be changed to another date because I won't be in town?
Nope. I'm
No?
sorry.
Okay.
You're very welcome. I told you that you can submit a letter, and we'll put it into the record and read it into the record. First case for tonight is case 16400, Fred Vasak, 200 Lake Avenue, St. James. Location, west side of Lake Avenue, north of Sherwood Drive, St. James, property zone R10. Request variance to increase the maximum paved surface in the front yard from 25% to 42% existing. Okay. May I have your name, please?
Fred Vasak,
And your address, Fred?
200 Lake Avenue, St. James.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you. You want to tell us why you're here?
Sure. Here for, I guess, the second time around to increase the space of my paved area in my front yard. We've had filed for this before, but I think the filing between the numbers and the percentages, something kind of got screwed up the first time around, so we're refiling, and I believe I had a meeting with Dave. He was in on that, and basically I think that's where we are. I think everything else was already looked through.
Okay. We did visit your property yesterday. Okay.
Okay.
We do go to all to the
Sure.
sites. All right? Is there anything else?
No, I think that's it. I don't think I affect any of the criteria here. Everything seems to be, pretty straightforward.
Okay. Planning?
The request is sort of substantial, but as I recollect, you had said that this had been signed off on, or there was something mitigating that happened in this. There was one survey that was not right, I think.
Yeah, I think when we submitted, there was a plot plan, and then there was a survey, and one showed one item, and another didn't show the complete driveway.
Right.
But the percentages that were filed were all correct. But I think when it got to the planning department, they looked at the plot plan and not the survey, and it kind of got a little misdirected with the numbers, the percentages.
Okay.
But the original plan did have the right percentages on it.
But this was also before the board as well, right?
Yes.
And my recollection is that that you had said, I thought you had said two things. One is that there were two plans and we were looking at the wrong ones, or somebody was looking at the wrong ones. But I thought you also said that in the field that there was an inspector who didn't catch, or we, the town, didn't catch something. Does that ring a bell?
I'm not sure.
Okay. Well, I don't remember the details of the conversation. I guess it was a meeting.
Yeah,
Certainly
Gloria and yourself and I had a meeting on it, and
Yeah.
I was really, of the fact that I really didn't want to submit again, because I thought I had everything right on the application, but something in the department got a little,
Right.
something went wrong with the numbers, the percentages. But we did it again, and we got a resurvey, got everything straightened out, and here we are.
My recollection, too, is that what's currently out there is smaller than
Yes.
the worst-case scenario of the two surveys that the town had before, the two plot
Yes.
plans. So it's scaled down a little bit.
Slightly, yes.
Thank you.
Okay. Okay. Any gentlemen, any questions?
No question.
Thank you so much.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Fairly moved and second. All in favor? Aye. Motion carried. Next case is case 16401, Michael Kalausis, 48 East Hill Drive, Smithtown. Location, east side of East Hill Drive, south of 50 Acre Road, Smithtown, Smithtown. Property zone R10, request variance to reduce the minimum side yard from 12 feet to 8, reduce total side yard from 28 feet to 22 for a 49 square foot addition to an open porch. Increase the gross floor area of a lot from 25% to 32% for a proposed 675 square foot second floor addition. And may I have the applicant, please? You're the applicant.
Sorry.
May I have your name, please?
Michael Kozlauskas,
And your address.
48 East Hill Drive, Smithtown, New York.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you. All right. Now, would you like this gentleman to speak for you?
Yes, ma'am.
Thank you.
Thank you.
May I have your name, please?
John Teufel, T-E-U-F-E-L, professional engineer, 707 Route 110, Farmingdale, New York.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Thank you.
I'm here tonight with Michael Kozlauskas, who is requesting a variance for side yard's aggregate and floor area ratio to add a 675 square foot second story addition with balcony and a 49 square foot addition to the south side of the front porch. The zone is R10 residential, where a 12-foot side yard and 28-foot side yard aggregate is required. And we are requesting 8 feet to the front porch addition and a 22-foot aggregate. I do have here copies of 15 consents from the neighbors, including the 2 neighbors next door. Also, and they're all identified as to the job. Also, I have a copy of a building permit and CO for an existing covered front porch at 35 East Hill Drive, which is exactly the same thing as we're proposing, if I could submit those to the
You can.
board. Two photos of the same thing.
Okay.
And that's the permit and the CO, and those are the neighbor
Okay.
ones. Thank you.
Okay. Thank you.
The proposed second-story addition and balcony is not going past the existing side yard of 14.2 feet on the north side. There are other second-story additions in the area. The proposed FAR is 32%, where 25% is permitted. This request is to allow for the proposed second-story addition of a master bedroom, full bathroom, and closet. The house presently only has one bathroom, one full bath, excuse me, which is difficult with the Kozlauskas' 3 children. They are also planning a 4th child, which is why we're requesting to add the new bedroom for a grand total of 5 bedrooms and 2.5 baths. The Kozlauskas have lived in the house for 14 years. Very happy with the area and wish to remain there, and just would like this extra space for their home. That completes our case.
Planning?
Nothing, thank you, Madam Chair.
Gentlemen? Okay.
We do have a neighbor that wanted to speak, if you
I
don't mind.
will let them speak
Okay.
after. All right?
Okay, thank you.
You're welcome.
Thank you.
You can sit down. All right. Is there anyone here that would like to be heard on this application? You may come up. May I have your name, please?
Michael Caputo,
Spell your last name, Michael.
C-A-P-U-T-O,
Okay. And your address.
46 East Hill Drive, Smithtown.
Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you.
Thank you. We have lived at our address since 1966, and we plan to stay also for a while. So these neighbors have shown us what they're going to do, and personally, we're ready to see it done. We are very happy with the improvement, and it's something that we certainly would like to see. It's a practical and beautiful addition.
Okay. Very nice.
Okay.
Thank you.
Thank you.
Is there anyone else? Okay. Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Sorelli moved to second. All in favor? Aye. Opposed? Motion carried.
Yeah.
Next case is case 16402. Elsa Alvalero Serial, 743 Town Line Road, Smithtown. Location, north side of Town Line Road, west of North Hoffman Lane, Smithtown. Property zone R10. Variance to permit environmentally sensitive land, slopes in excess of 15% to be altered. Permit structures within 10 feet of environmentally sensitive land. Reduce minimum setback west side of a 4-foot fence from a retaining wall from 6 feet to 0. Reduce the minimum setback east side of a 4-foot fence from a retaining wall from 5 feet to 1 foot. Reduce the setback retaining wall from 6 feet to 0 west side. Reduce the minimum setback east side of a 5-foot fence from a retaining wall from 5 feet to 0. Increase the maximum height of a retaining wall and fence west side from 6 feet to 10 feet. Increase the maximum paving in the front yard from 25% to 38%. Okay, and your name, please.
Hi, my name is Elsa Alvarado Serial, 743 Town Line Road,
Okay.
Smithtown, New York, 11787.
Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes.
All right. Now, the two gentlemen going to speak?
John.
I'm her husband, Antonio Surreal.
Are you going to speak to him?
Well, we have a representative.
Okay, so why don't you sit and then I'll have him. All right. Again, may I have your name, please?
Yes, John Tufel, 707 Route 110, Farmingdale, New York.
Okay, I've already sworn you in, so, okay, you can present, please.
Thank you. As we mentioned, we are seeking to maintain a retaining wall varying in height from 1 foot 0 inch to 5 foot 8 inches with a 3 to 4 foot high fence from 0 to 1 foot from the east and west property lines, and to increase the maximum paving in the front yard along Town Line Road from 25% to 38%. Swimming pool permit number 113374 was issued on April 18, 2003 by the town to Mr. and Mrs. Suriel after they were informed by the, then after the permit was issued, they retained a contractor to do the project, and the contractor informed them that they would need retaining walls to install the pool because the backyard was sloping towards the rear. They authorized the retaining walls, assuming, totally that the contractor would get any permits. That's what he indicated. They just, thought that that would be the case, so they were kind of ignorant of this whole thing until April of last year, when Mr. Sorrell was informed by the town inspector that the contractor had never obtained these retaining wall permits, and there was a problem. We'd also like to point out that Mr. Sorrell's immediate neighbor to the west, at 741 Town Line Road, has a backyard swimming pool with similar retaining wall, which we believe has been granted a CO by the town. Also, the overall grade of the 107-foot-long Sorrell backyard is only 11.9%. That's the way it is now if you measure it from the house to the back property line, which is less than the 15% specified by ordinance. And finally, the grade of the backyard as it exists today is actually beneficial to Mr. Sorrell's backyard neighbor, as there is much less tendency for rainwater to run down towards the back of the property into the rear neighbor's yard. Also, there was, Mr. Sorrell was in the house for about 2 years before the pool was constructed with the retaining walls, and there were issues with soil erosion in the backyard, again, sloping down away from the house, which the retaining wall has alleviated. But again, it was just a mistake. We're not trying to justify it. They thought the contractor had obtained this, and he didn't. Regarding the front yard paving issue, the driveway existed as it is today when Mr. Suriel purchased the house in the year 2011, years ago. The builder had put it in, as we do believe that whatever site plan the builder had filed with the town at the time showed the driveway the way it is now. At that time, the town did have a comment with the builder about the 2 curb cuts, because it is, as you can see, it's a U-shaped driveway, and there were 2 curb cuts installed. The curb cut to the west has been filled in. That was the town's comment back in early, year 2000 in that area. The town was aware of it, and they filled in that curb cut and really thought that was the end of the whole thing. The size of this driveway does contribute positively to traffic safety, as it removes any requirement to back onto the very busy Town Line Road. Also, there's no shoulder here along Town Line Road. There's no street parking available. A check of the Bing map aerial photographs, as well as my inspection of the neighborhood, shows that both the immediate east and west neighbors, as well as many homes in the neighborhood, have a driveway which appear to be in excess of the 25% permitted. And that basically completes our case, and we'd appreciate any leniency that the board could extend to us regarding this.
Planning?
Chair.
Gentlemen?
One question. You said that the curb cut to the west was removed because your plot plan is showing it as existing.
Yeah, it was there today. You know, it kind of blends in well with the curb, but if you look, the one to the west is not a curb. It's a curb. It's not that high. It's only
So the driveway exits there or does not?
well, the driveway goes there, yes, but there's no dip in the curb. The curb extends across there.
Okay, thanks.
Okay. Thank you. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Readily moved and second. All in favor? Aye. Motion carried.
Thank you.
You're welcome. Next case is case 16403, Christopher Nealis, 92 Rumford Road, Kings Park. Location, south side of Rumford Road, east of Amapola Lane, Kings Park. Property zone R10. Request variance to reduce the minimum side yard from 12 feet to 7, reduce total side yards from 28 feet to 20 for an existing 218 square foot deck. Reduce the minimum rear yard from 50 feet to 30 for an existing 332 square foot roof over patio. And your name, please?
My name is Christopher Nealis. I live at 92 Rumford Road in Kings Park.
Raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Thank you. Okay, you want to tell us why you're here?
Yeah, I'm here because the town had a complaint about a deck that I've had since I bought the house in 1993. That's the existing deck, and apparently it's too close to the adjoining property. And last year I had a small roof put over my partial of my patio, so I want to get the existing the variance for the back of the yard. And with the roof over the patio, it was my own fault. I was mistaken. I thought that since it wasn't an enclosed structure, that it would be okay. It wouldn't be subject to variance.
Okay. All right, let me ask you a question. The deck was there when you bought it.
Yes.
Were you represented by a lawyer?
Yes.
And the bank never picked it up?
Apparently not. I wasn't even aware of it until about less than 6 months ago.
You know, it is not, it's definitely not in the character of the neighborhood. You must have had a back door. Is that out of your kitchen?
Yes, it is.
They must have had a back door, and what happened is they must have changed it to the side, and that's why they put the deck to the side.
Yeah, but I mean, I haven't had I haven't had a neighbor complain in
Yeah, well.
18 years, and it's not that big of a deck.
All right.
And that's where the way the house is. It's a raised house, so the deck is level with the sliding door in the kitchen.
I understand that. We were there yesterday.
Okay.
Planning?
I have a question. If the board didn't grant the variance, how would it affect the use of your house?
Well, it would be, I wouldn't be able to get into my backyard, basically. That's the only way I can get into my backyard, through the kitchen.
Okay. Thank you.
Gentlemen, any questions?
No.
Gentlemen?
No question.
Okay, thank you.
Okay, thanks. All right, is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
It's ready, moved, and second. All in favor? Aye. Motion carried. Next case is case 16404, Extra Space Storage, 281 Indian Head Road, Kings Park. Location: east side of Indian Head Road, north of Old Northport Road, Kings Park. Property zoned LI. Request variance to reduce side yard from 20 feet to 5, reduce total side yards from 40 feet to 20 for proposed 150 square foot deck. And your name, please?
James Bambrick, B-A-M-B-R-I-C-K, address 281 Indian Head Road, Kings Park, New York.
Okay, raise your right hand, please. You swear to tell the whole truth and nothing but the truth?
I do.
And are you the owner of this?
No, I'm the manager, the site manager. I just presented power of attorney from the...
Okay, let me just make sure if that power of attorney is correct.
I'm not an attorney, so I'm not qualified to say whether it's correct, but it says it's a limited power of attorney. It's regarding a variance, and it says, I, Gwynn McNeil, Vice President of Extra Space Management, Inc., do hereby authorize James Bambrick, an employee of my company, as its agent to represent my company and to otherwise act on its behalf concerning a proposed variance to build a deck at our facility located at 281 Indian Head Road, Kings Park, New York. I understand and agree that his or her conduct for this action will be binding on my company. There's a signature, and the printed name says Gwynn McNeil, and it's notarized by Trinette Drummond, State of Utah, sworn April 25th, 2011, and signed by the notary.
It's not the correct form. Am I correct?
I don't know.
Is it just a handwritten, is it just typed, a typed paragraph?
Yes.
There's a standard form that has to be filled out.
The planning board told me just 2 days ago that all I needed was this letter. Sue at the planning board.
I don't know. I mean, I've only heard the staff say at other cases that it has to be a specific form.
It does have to be a
I don't know what they said in this case, but the only time I've ever heard them tell people is a certain form.
I don't know what to do. All right.
Could I just?
Yeah. Let me, what if I do it at the end here? The attorney is going to be late. She won't be here until probably 8:30, 9 o'clock. I'll tell you what I'll do. I will hear it. If she doesn't approve this this letter, I'm going to have to make you come back.
Okay,
Okay?
whatever you say, ma'am.
All right. Okay. Okay. You want to tell us why you're here, please?
Yeah, we're requesting, yes, ma'am. We're requesting a variance so that we may build a small deck on the north side of the property, adjacent to the apartment that's on the property, so that we may have an area to sit outside other than the parking lot, which is what we do now. Our neighbor
Yes.
to the north is Tennis Time. They use a house as their corporate headquarters, and that house has a very large, extensive deck. So it's in keeping, I believe, with the character of the neighborhood. And that's pretty much it.
Okay. Okay. Gentlemen, any questions?
No question.
Good.
What will the deck be used for?
Strictly to relax outside, just,
Okay.
get some sun, fresh air, that kind of thing.
Will it have a roof?
No,
Anything that is fire, anything flammable? I mean, obviously furniture, but what I'm thinking of specifically is any grills, fireplaces, anything like that?
nothing, no, nothing
Thank
of
you.
that nature.
Thanks.
Okay. Okay. All right,
Thank
thank you. If there is a problem, I will get in touch with you.
Thank you very much. I
You're very
appreciate
welcome.
your time.
Is there anyone here that would like to be heard on this application? Come up, please.
Hi,
You need to take that mic down for yourself,
Okay.
okay? Thank you.
All right.
And let me have your name and address.
Sheila Weber, 319 Old Indian Head Road, Kings Park.
Okay, spell your last name.
W-I-E, B as in boy, E-R.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Thank you.
My main question was also the purpose of the deck. We do live across the street. There is some noise from the storage center with alarms going off and things like that, and I just wanted to know, was there any nighttime activity planned?
Not that we know of. I mean, it's
Is there any ordinances that would go along if the deck was approved, that they'd have to be in compliance with?
As far as what, that they couldn't
Music,
sit on the
nighttime
deck?
music, 3 o'clock in the morning. Like I said,
Oh.
3 o'clock in the morning, I have alarms going off. So I'd also like to know what's planned for the deck then.
What-
My recollection, it's been a month or two since I've seen the plans, but I think the deck is 90% of the way toward Indian Head Road.
Okay.
It's facing the Sport Time parking lot, but at the west end of the wall, and maybe the owner can confirm or correct me on that when he comes back to the podium.
Okay. All right.
Okay.
Thank you.
You're very welcome. Anyone else? Okay. Can you come back to the podium, please?
My wife and son and I live in the apartment. We're the only ones who live in the apartment. We strictly want the deck so that we have a place to go outside and not be sitting in the parking lot. When we sit outside in the parking lot on a Sunday, we tend to have customers come up to us and ask us to do them favors or to open units or to open the dumpster or do other things that are part of our job, but not on Sunday. So we simply want a place to sit outside on Sunday and enjoy the weather. So as far as noise is concerned, I don't think there would be any noise of any kind whatsoever. The deck is at the very front of the property, almost all the way to Indian Head Road, which would put it, I'm not sure exactly how many 100 feet from Old Indian Head Road, but quite a long way. Okay?
Thank you.
Yes, sir.
Different time. Can you just talk to us sometime about the alarm situation that the woman brought up?
Yeah, there definitely can be random alarms that do go off at night, primarily driven by the wind. And we do our best to minimize that by disabling the alarm. I'll get up in the middle of the night and turn off that alarm for that specific unit. The doors on the units are roll-up doors, and when the wind blows strongly, certain units tend to go off. There's other things, you know, on a Sunday afternoon, if somebody comes in and follows somebody through the gate, they'll set off the alarm, that kind of thing. And we ask our customers not to do that.
Okay.
Thank you.
Thank you.
Okay. I'll entertain a motion to close the hearing.
So moved.
Second?
Barely moved in seconds. All in favor? Aye. Motion carried. Next case is case 16405, Max and Michelle Mills, 27 Rensselaer Drive, Comac. Location, north side of Rensselaer Drive, east of Yates Avenue, Comac. Property zone R10. Request variance to reduce the minimum front yard from 40 feet to 36 feet for an existing 36 square foot portico.
Hi, how are you?
May I have your name, please?
My name is Max Mills. I reside at 27 Rensselaer Drive, Comac, New York, 11725.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Okay. You want to tell us why you're here, please?
I'm here today to try to get a variance for a portico at my address at 27 Rensselaer Drive. I've had contract work done on my house from BZA Construction Company. I was not aware that I needed a variance. I thought I needed a permit, but I have 38 feet, not 40 feet from the premise, so I was told that I needed a variance. So I'm here today applying for a variance. The reason why I'm getting the variance is so my price value and the surrounding houses near me go up. I just did some construction on my house. My neighbors directly to the left of me have a portico, and my neighbors 2 doors down have a portico. Across the street from me, I have a sump, woods, so there is no neighbors across the street from me or anybody else that would see it or it would bother them.
Planning?
Madam Chair.
Gentlemen? Okay, thank you.
Thank you very much.
Is there anyone here who would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second?
Ready, moved and second. All in favor?
Aye.
Aye. Motion carried. Next case is case 16406, Camille Strobel, 42 Arlington Avenue, St. James. West side of Arlington Avenue, south of Rutherford Road, Street, St. James, property zone R21. Request variance to reduce the front yard setback from 50 feet to 47 for a 137 square foot porch existing. Reduce the minimum side yard from 16 feet to 10 feet and total side yard from 34 feet to 27 feet for an existing 1,198 square foot barn. Reduce the minimum side yard from 16 feet to 13 and total side yard from 34 feet to 30 for an existing 176 square foot shed. Reduce the minimum rear yard setback from 8 feet to 4 for an existing 177 square foot shed. Reduce side yard from 16 feet to 0 and total side yard from 34 feet to 0 for 4 and 6 foot corral fences existing. Reduce setback for corral fences in rear yard from 6 feet to 0 existing. Reduce front yard paving from 25% to 58% existing. May I have your name, please?
Hi, my name's Camille Strobel, 42 Arlington Avenue, St. James, New York.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Okay. Would you like this woman to speak for you? Okay. Thank you. May I have your name, please?
Certainly. Sharon O'Brien, 54 Meadow Island Road, Mount Sinai, New York.
Okay. Will you raise your right hand, please? Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Okay.
Good evening, Madam Chair and members of the board. As previously stated, I'm Sharon O'Brien, and I'm here acting as agent for Mrs. Strobel. The subject property is situated on the 12th map of Agricultural City, part of Lot 572, filed August 10, 1877. The property, an improved parcel in an R21 zoning district, fronts Arlington Avenue with 116 feet of road frontage, with 453.30 feet in depth. The lot area of the parcel is 52,582 square feet. We are before you this evening seeking permission to maintain 2 sheds, a barn, paving, and a roofed over front porch that were existing when Mr. and Mrs. Strobel purchased their home at 42 Arlington Avenue, May 19, 1998. They never intended to move from their home. They enjoyed their home until recently. In 2007, Mr. Strobel passed on, leaving the burden to Mrs. Strobel to legalize everything. I'd like to submit an aerial photo from 1992.
I know, we were there.
As you can see, the 2 sheds and barn were existing in 1992. In conversation with Allison and David Flynn, upon closer examination, they were able to determine there was quite a bit of paving in the front yard at that time. It was their opinion, comparing the aerial and the survey, additional paving may have been added along the north property line. I'd like to submit a photo showing a large green buffer along the north property line where the driveway is located. And there are also, excuse me, photos of the subject property, south property line. The north property line where the barn is located will demonstrate the barn is not adversely affecting the neighbor contiguous to the north. That area has remained natural and undisturbed.
Okay. Let me just tell you, if you want these pictures to be put into the file, we will look at them, and I will give them back to you. You need to, first of all, date when the pictures were taken, who took the pictures, what the case number is. Okay?
I will do that.
Okay. So let me show everyone, then I will give them back to you.
Okay, I have additional pictures that I'd like to submit that would be part of my presentation.
All right. They all have to be labeled on the front.
I will definitely do that for you.
Okay. Thank you.
Okay, the additional pictures I'd like to submit are of the neighborhood. Number 46 Arlington Avenue, the residence contiguous to the south of the subject has a paved circular driveway and brickwork near the front door, and paving along the south property line to access a second residence behind. Number 50 Arlington has a circular driveway and additional paved area to park, and you will see a truck parked on the property. South of that is number 50. South of number 50 is the oil company, and you will see that there are numerous trucks parked, and the paving is very extensive. Going further to the south is Middle Country Road, and on the corner of Middle Country Road and Arlington, there are 2 car dealerships, the Honda dealership and the Nissan dealership. Arlington Avenue is used as a test strip for potential new car owners. So needless to say, a circular driveway is a safety feature. During my conversation with Dave Flynn, it was mentioned that there was concern as to the use of the garage conversion. So I also have photos that I would like to submit showing that it is a den area. And to clarify, the residence has always been used as a one-family dwelling. In closing, we would like to ask the board to look favorably on our application because we feel by maintaining the property as it stands, we are not adversely impacting the neighbors, neighborhood, or the environment, and we are definitely conforming to the nature and character of the area.
Right. Just let me tell you, you handed me these pictures of different paving on the street. We get these exhibits, but we have no idea if these paving have a CO or when the paving went in, before the ordinance or after the ordinance. Do you have any details for every one of these driveways that you have given us, if they have COs and when the paving went in?
Okay, I did research through the property cards, and I was unable to come up with that information.
Okay.
But as you can see, the area is business and residence. It's a very unique area.
We're well aware of that, but what I'm saying, you know, you hand in these pictures, I do not know if they have COs, if the other people have COs. I'm just
Well,
asking you that.
the only thing I can tell you, Madam Chair, is there was no indication on any of the property cards when that actually took place.
Okay.
The only thing that I could possibly do is go back through aerials. I could go to the planning department, and we could go back through the aerials. Would that be possible, Mr. Flynn? And perhaps we can determine when the driveways were put in.
Okay.
Would that be acceptable?
That's fine. If you're going to look at the, do you want to keep the record open?
It's up to you, or yeah, it's up to you.
If I close the hearing and I can keep the record open, then you could submit any other information if you'd like to,
Okay, that would be fine.
okay?
And then we would come back in front of the board at a
No, if the
different date?
record's open, you don't need to come back.
Okay.
unless- Right? Keep it open.
Madam Chair, possibly if Mr. Flynn is available tomorrow, we could do that research?
I don't know if,
There are like a few other planners that you could work with.
Oh, okay.
I recommend Allison.
Okay, I'll work with Allison
Okay.
then.
But I would call first
Okay.
before coming in. If I might say, Madam Chair, the only thing the planning department's, or the main thing that we're concerned with is the paving in the front yard.
right.
And in the sense of fairness, the board has denied smaller requests in the past. Two of them, I believe, are still in litigation. And, you know, I'm somewhat concerned that granting something here and denying others, if the circumstances are similar, would hurt the pending litigation, or not pending, the actual litigation. Ms. O'Brien brought up, I guess, the fact that they're close to an industrial district here, but the board's supposed to grant the minimum relief necessary. Having said that, the aerial photographs did show more paving in the front yard than what is typical, but less than what is there today. And I believe the photograph that we looked at was from 1992.
92. We tried to review the 99 aerial prior to the ordinance going into effect, but it was too dark. We couldn't determine it on that aerial, because the ordinance actually came into effect in 1990, if I'm correct.
Either 1989 or 90, I'm not sure which.
Yes.
I think it's 89, yeah. All right. Gentlemen, do you have any questions?
No question.
Okay,
Okay.
all right.
Yes, thank you very much.
You're welcome. Is there anyone here that would like to be heard on this application? Okay. Hearing none, I'll entertain a motion to close the hearing, but keep the record open.
So moved. Second?
Okay, all in favor?
Aye.
Aye. Motion carried. Okay, case 16408, Condon Enterprises LLC. Didn't I do that, closer? Okay, I just did that. Oh, no, I didn't. Okay, sorry. The next case is case 16407, Dorothy Clauser, 42 Cedar Street, Kings Park. Location, west side of Cedar Street, north of Lou Avenue, Kings Park. Property zone R10. Request variance to reduce the minimum side yard from 12 feet to 3 and total side yards from 28 feet to 15 for an existing 96 square foot shed.
Morning, Madam Chair and members of the board. Janet Haberly here on behalf of the applicant. Power of attorney has been given to Mr. Flynn.
I'm assuming that's the correct power of attorney?
Yes, ma'am, it is.
Yeah. Okay, raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Absolutely.
Okay.
The application before the board is for a side yard variance for an existing 96 square foot shed, 12 by 8, which was built in the 1980s. As you can see from the survey, this is a very oddly shaped lot. It's almost a triangle, and the property, its narrowest point slopes upward. Would be difficult for the homeowner to have the shed further back than it is, which is already 30 feet away from the house. The reason that we're here for a side yard variance is that the shed is not located within the last 50 feet of the zoning of the property for the zoning district R10. It's actually 7 feet in from there. It's 57 from the rear. Hence our need for a side yard variance. The adjacent neighbor to the south, Gary Mullins, has a shed also, as you can see from the photos that was submitted with the application. He's also signed an affidavit, which I have just presented to the board in support of our application, and he is the neighbor that is right adjacent to Mrs. Clauser's house and is most affected by that structure. She's the original owner from 1966. We have existing permits on file for the deck, 129938. That also includes a garage conversion. And another permit, 130049, for 4 bay windows she constructed. There are no environmental concerns here. There's no negative impact on the neighbors as per the affidavit that was submitted by the adjacent property owner. The other neighbor on the other side is all the way, well, through woods. You can barely even see the house. And the shed is on the opposite side of the property, so it doesn't have any negative impact on them. The only alternative that we have would be to remove the shed, which would cause her some hardship. First of all, because of the garage conversion, she has no other place to store anything. And additionally, that shed is equipped with underground electric, so that would kind of pose a problem for her if she had to move it or to another situation. So it is a self-created problem, and we just ask the board for its consideration. Thank you.
Planning?
Madam Chair.
Gentlemen? Okay. Is there anyone here that'd like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
All in favor?
Aye.
Aye. Opposed? Motion carried.
Thank you. I'm either late or early.
I don't know. Okay. Next case is case 16408, Condon Enterprises LLC. Location, southeast corner of Alexander Road and Route 347, Lake Grove. Property zone, SCB. Requested interpretation, whether the required parking for this shopping center is 1 space per 100 square feet or 1 space per 166 square feet of gross floor area.
Madam Chairman, members of the board, my name is Vincent Tremarco. I represent the applicant. My offices are at 1038 West Jericho Turnpike, Smithtown, New York. I guess you recall that we were here, I could say last year, and there was a decision made on December 17th and December 15th. I don't know why they're two different letters, but basically, we requested a variance to reduce the required parking. At that time, I indicated to the board that, and I thought we made out a pretty good case, that it really should be 166 square foot for every parking space. And for whatever reason, I'm not sure if it was your council or this board's collective decision, well, it had to be the board, I guess, eventually, and you said, in effect, that I should have asked for an interpretation.
Right.
I don't agree with that, but that being the case, I spoke to my client, Mr. Bregman, who's here tonight, the owner of, or managing member of Condon Enterprises, and he is so concerned about this situation that he said, well, how are you going to get back to the board? I said, well, I guess we'll have to ask for an interpretation. And he said, okay, go ahead and do that. And that's why we're here tonight. I really don't think we should have had to come back again. I think, and I don't mean it in a disrespectful way, but I think the board had the power and the ability to grant us the request using 166. One of the statements that was made was to the effect that the town board acted illegally in the past, granting the 166 criteria to the Condon property. You all know where the Condon property is. It's in front of the mall, and I think we'll show you tonight, by virtue of the fact that Fred Meyer is here, and he will testify, and this board will know from Mr. Meyer's mouth to your ears what happened and why it happened the way it did. So I'm going to call Mr. Meyer now. I'm then going to ask the owner, Paul Bregman, to speak, and then I'm going to submit to this board about 18 documents that Mr. Bregman prepared, all marked, so that your counsel and you can review those documents just to make sure that we're not telling you a story tonight that's not backed up by documents and letters and maps that go back 40 years. Okay, I'd like at this time to call Fred Meyer with the chairwoman's position. Mr. Meyer.
May I have your name and address, please?
My name is Fred Meyer. My address is Tuthill Lane, Remsenburg, New York.
All right. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you.
I was the town planner for 25 years, and under my watch, I think the town board and the planning department made some great strides and accomplishments in improving this town. One that I can think of is the ability for a developer to cluster zone his property. So he was able to reduce the lot size of his property, and all the excess land, woodland in most cases, that was dedicated to the town of Smithtown and would remain forever open and wild. Another thing that I think is a landmark decision made by the town board was the provision in the zoning ordinance to permit townhouse condominiums. We have some very attractive townhouse condominiums, and they're here because of the enabling legislation. The third thing we did was to enable the Smith Haven Regional Mall to come into the town of Smithtown. And in the zoning ordinance, under regional shopping center, there are certain provisos or minimum requirements. One is that it be no less than 30 acres and serve a population of no less than 150,000 square feet. The application that you heard recently was to determine whether this applicant, Smith Grove Shopping Center, should adhere to the parking standard of 1 parking space per 100 square feet. That parking ratio is typically set forth for neighborhood shopping business. We're not a neighborhood shopping center. This board determined on its own to reduce the parking to 530 spaces. We only need 521, so we have a little slippage there. Parking was adequate, but we wanted to protect and buffer the 1-acre houses to the south, and no, to the north rather. And so we eliminated parking in the rear of the building to increase that buffer. We did many things in those days. I presume planning department is still doing it to some degree, but we had many, many miles of roads built without any cost to the town. We urged, I use that word cautiously, we urged developers to cooperate with the town and pave town roads that were underdeveloped. One road I can think of in the hamlet of Nesconsett is Nichols Road. It was just a 2-lane oil and sand roadway, and we required it to be widened. It now serves as a collector street. We did the same thing in Hauppauge with Bow Drive, all built not with town funds, but with developers' funds. In any event, I respectfully urge you to consider Smith Grove Shopping Center parking to be calculated at 1 to 166 square feet, because it is intrinsically a part thereof.
Thank you so much.
Thank you.
Madam Chair, I just have a couple of questions for Mr. Meyer. Okay. Mr. Meyer, during your...
Mr. Tramarko, you know what you need to do? Take that mic with you or
Okay.
pass it back and forth.
Mr. Meyer, during your term with the town of Smithtown, and particularly with respect to your dealings with Walter Bregman, Paul Bregman's dad, was there an agreement that the parking ratio would be 1 parking space per 166 square feet? And was it also recommended by you and the town board that it would be part of the entire shopping center of Smith Haven Mall?
The answer is obviously yes. The town board and I, John Klein was the supervisor, Otto Schubert was a member of the board, Peter Noack was a member of the board. They were all pro-development for this town, and they urged me to do whatever I could do to serve the town and encourage development here. When I came, the population was 60,000. When I left, the population was 126,000. We underwent many, many changes. But yes, the answer was the town board and I, in concert, looked at Smith Grove Shopping Center to have a parking ratio of 1 space for around 166 square feet. They could not have provided 1 parking space per 100 pursuant to a typical neighborhood shopping center.
Okay,
Thank you.
yes.
Thank you, Mr. Meyer. I'd now like to call Paul Bregman, and he'd just like to make a few comments.
May I have your name, please?
Yes, Paul Bregman, 33 Picardy Lane, Laurel Hollow, New York.
All right. Spell your last name.
Bregman.
And raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do. Thank you. Good evening, Madam Chair and members of the board. And I'd like to take a few minutes to make some comments as owner of the subject property. I would like to think that my counsel, Vince Trimarco, along with Fred Meyer, the former planning director of the town of Smithtown, will make the case for Condon, proving that the board should recognize Condon's right to maintain the parking ratio for the shopping center at 1 car per 166 square feet. I have been associated with the property for more than 30 years. As you are aware, my father, Walter Bregman, developed the site and was involved from inception. He was the person who worked with the Winston Mall, now known as the Smith Haven Mall, to purchase the property and worked with various town agencies and officials, including the planning department and Fred Meyer, to obtain all the necessary approvals to construct the shopping center. Based on the testimony of Fred Meyer, Condon and the town cooperatively worked together to achieve a retail shopping center which would serve the community alongside the Smith Haven Mall and benefit the town and the patrons of the shopping center. A substantial component of the cooperation between Condon and the town was the dedication of a portion of land owned by Condon, almost 14,000 square feet, for the purpose of the town having the ability to widen Alexander Avenue, which was significantly smaller and was significantly smaller road prior to widening, which was done many years ago. As Mr. Meyer stated, there were many reasons for the town to have considered our property integrally combined with the mall. However, a major reason for Condon to have given up the land along Alexander Avenue was the consideration of Condon receiving a parking ratio of 166. It is important to note that if the land had not been given to the town, we would have had the potential to construct an additional 3,200 square feet of building based on the current building coverage. We also would have had the benefit of additional sanitary density and additional parking. As my counsel has related in the past and will relate tonight, the Smith Grove Shopping Center has been utilizing the parking ratio of 166 since 1970, over 41 years ago. It is quite incredulous to think that after 41 years and no less than 7 affirmations by the Board of Site Plan Review, plus a number of other approvals which were granted by the Town of Smithtown Planning Board, that the Zoning Board believes we are not entitled to enjoy the parking ratio granted by the Town of Smithtown and repeatedly affirmed by the town and on which Condon relied. It is also important to note that at no time in my 30-year tenure working intimately with this property, until very recently, did any official from the town, including the current planning director, indicate to me or anyone in our company that there was an issue with our current parking ratio or that there was an improper deal made that we were not entitled to the 166 ratio. I've been in the development business for more than 30 years, and it is commonplace for a town and or municipality to work cooperatively with developers. Condon does not believe that any improper deal was made with the town. In fact, we believe there are numerous projects in the town that have had similar cooperative arrangements, and Mr. Fred Meyer has related a few of those. More importantly, for this board to now say that an approval for the parking ratio granted over 40 years ago, affirmed by the town board numerous times, and planning board is no longer valid, and that the town should now receive the benefit of valuable land for no consideration is remarkable, injurious to Condon in numerous ways, and completely unacceptable to Condon. We hope that the vast amount of evidence presented tonight will convince this board that Condon is entitled to maintain the parking ratio of 166 in perpetuity. Thank you again for giving me the time to make my thoughts in regard to this matter.
You're welcome. Okay.
Well, after these two gentlemen, the only thing I'm going to do, so I don't say anything I shouldn't, is I'm going to submit to you a set of documents that were prepared and collated by Paul Bregman, along with a little dialogue or memorandum that he sent to me. And it's exactly how he sent it. I've not changed a word of the memorandum. You're going to have 18 documents submitted to you. I'm going to give it to you in this expensive folder that's all labeled and everything. There are 18 exhibits, which I'd like to just present to you this way. And I just have one final thing to say. You might think to yourself, as you did grant us the variance the last time,
we did.
Well, what's the difference? Well, the difference is, first of all, you granted a variance from 866 cars to 500 and 30. And I think the real reason why you did it in your collective minds was the fact that in the back of your mind, you thought that, hey, this is really 166, one parking space to 166. And so you gave us this gigantic variance. Well, the truth of the matter is, it really should be 166. It probably should have been done the last time, but maybe that's my fault, and I should have been smart enough to ask for an interpretation. Now you have the interpretation request before you. I think that after you read those documents and you think about what Mr. Meyer said and what Paul Bregman said, I don't think there's any other conclusion but to continue, well, to interpret it as 1 to 166 and make that for the record, and that's what it should be, notwithstanding what the current shopping center, neighborhood business requirement is. You know, I've been to the mall, I guess, as much as anybody, and many times, if I want to go to Dick's Sporting Goods, I'll park in Condon's parking lot because it's close and it's easy, and it makes sense. And I think that was what was in their mind many years ago when the town board decided to grant the ratio of 1 to 166. So it was a collective thing. I don't think I could say it any better than these gentlemen did before me, so we ask the board for its favorable consideration. Thank you.
Okay, thank you. Planning?
Madam Chair, the only comment we have is the director, the planning director believes that, or doesn't know how the town board, let me correct that again, that the Board of Site Plan Review had the authority to make that kind of a deal.
Okay.
I just want to try and get it clear in my head while you have Mr. Meyer and Mr. Bregman here. Apparently, the two sites being contiguous, the benefit of the parking reduction was given to this site being because it was contiguous to the regional mall. Now, playing devil's advocate, if the regional mall went away and was rezoned down the road and we were to grant this to 166, one of the reasons that I think that they work together is that there is excessive parking directly adjacent to this. So if there is an excessive use on this site, that there's a place for those cars to go. Suppose 20 years down the road that mall isn't there anymore and we grant this variance to 166 and there is no place for these additional cars to go. By virtue of the fact that the property is adjacent to it, to me isn't justification that it should have the same regulation. Your ability to come to this board to get relief, which was granted last time they were here, would seem to me to suffice for the zone that it's in. The concern that I have is, what about somebody else that has a piece of property adjacent to a regional mall? Are they able to get the same relief?
Well, I guess it's, I haven't really expressed myself correctly. You're going to have 18 documents that, if you have the time, you could look at, and at least 7 or 8 times, the town board, not some guy in the street that decided to change the ordinance. The town board signed the site plan. That site plan said 1 to 166. Notwithstanding what the planning director said, in effect, he's saying that the town board committed illegal acts 7 or 10 or 15 times, however many times that they voted for this site plan with the 166 parking. Additionally, I think Frank DeRubius, if not once, twice, this site plan, I don't know which, was it for a restaurant or whatever, he signed off on the 1 to 166. So now it becomes, you know, some kind of a, you know, a new thing that all of a sudden now we're stuck with the 1 to 100. And by the way, Mr. Tan.
I don't mean to interrupt, but I'm just struggling with the fact that I don't disagree with you that they may have been given the benefit of that through the Board of Site Plan Review or the Planning Department or whomever. But the relief through this board, our ability is to grant variances from the zoning. To come and ask us to at least for me, to come and ask for us to interpret that it should be 166, it seems that the justification you're saying is that that's the way the town always looked at it, which to me doesn't really kind of float. If you said it should be 166 because this is 30 acres, because it meets all the criteria of an RSS zone, then I'd be able to handle that better. It's just a little bit difficult for me, in my mind, to justify it just because it's next to the other shopping center, and that's because the way it's been done by the
Well,
town.
then again, I guess it wasn't clear that when this, and I think Mr. Meyer said it, as well as Mr. Bregman, that this was treated as one entity from the very beginning. If you recall, Mr. Meyer said that Alexander Avenue was a two-lane road. Walter Bregman, Paul's father, and the mall, Smith West, whatever the heck they were called at the time, they donated, dedicated 40 feet of property, as well as Walter Bregman, to widen the road. And I think that was one of the quid pro quos that Mr. Meyer sought to get to alleviate north-south traffic on what was to become a major road in the future. And then remember the ring road, which everybody calls it a ring road. I don't know why, but I guess it partially circles the mall and the Condon property. And what Fred Meyer said, there are curb cut openings precisely for the fact that they would be used. It's like a symbiotic relationship. Now, you know, you said, well, supposing the mall goes out of business 20 years from now. Well, I guess that would be something that, you know, we would have to look at 20 years in the future. And if they go out of business, I'm not so sure that, you know, the Condon Shopping Center would be in such great shape.
Well, I'm only saying that to kind of put it out there that, you know, we grant the variance, it's in perpetuity, it runs with the land, it has absolutely nothing to do with anything around it. So at least in my mind, I'd like to justify, or have reason to justify, making that interpretation that this should be looked at.
Right, and I guess after you look at the documents and you read the record and so forth, I mean, the only person that ever brought this up, I think, is Frank DeRubius, because he felt, and I'm not going to say that, you know, I'd say his position is wrong, but nobody else ever questioned it for years and years and years. And now all of a sudden, everything that was done in the past was basically, you know, said to be illegal, and nobody ever had the right to do it. So what happened for all of those years? And by you granting 1 to 100, I mean the board, we don't know what's going to happen in the future. And I think we should enjoy the same parking ratio that the mall does. It would be, you know, the mall has, I don't know how many restaurants, and a lot of them, you know, would require in a normal setting because they're counter service. I think it's 1 to 50, David. If the mall was subject to that type of requirement, they would have half the restaurants that they have in the food court. So it is an important thing, and I don't know, you know, why they made the deal that they did, were it not for the town to give them back something. So to give them 40 feet of road along, 40 feet of property along Alexander Avenue was a big thing.
Mm-hmm.
So I think the board should, you know, consider all of these things and you know, use the 1 to 166. I think Mr. Bregman wants to say something.
Yeah, but I'm going to ask you to make it very brief, all right? Please.
I'd like to say something, too.
Go ahead, very briefly, please.
I would just like to address Mr. Tanzi, his problem with other shopping centers coming in, another regional mall, and another contiguous shopping center there too. Well, there will not be another regional mall in Smithtown. There's only one, and there only will be one. In order to assuage your conscience on the one parking space, 266 square feet of floor area, I hate to say this, but you've made that determination, really, for this piece of property. And if the mall did go, you and we would benefit, but the town would just have to eat it. We could not possibly ever subscribe to neighborhood parking requirement, which is 1 to 100. I think you knew that when you made your last decision. Perhaps, you know, looking into the future, maybe the mall won't be there. Maybe Smith Grove won't be there. Maybe they will have what we call in planning a higher and better use. And then we're all absolved from the problem.
Okay, thank you.
When
Very
we came
quickly.
into the last hearing, it was believed that that variance that we were not really seeking, the 1 per 100, we were told we had to come in with that with that parking plan because Frank DeRubius insisted he wasn't going to approve anything unless we came in for that variance. So we were forced to come in for that variance. It was my counsel's intent to get the interpretation at that time. All of these facts that you have before you remain the same today, remain the same at the last hearing. Condon has relied on the town's actions. Condon has relied on repeated affirmations of town boards and planning directors and planning departments repeatedly. We look at this, obviously, as a very serious issue. So we hope that you will find in our favor.
Thank
and
you
I
very
hope that
much.
you can find justification in all of the documents.
Okay, thank you. All right, Mr. Tramarko, I'm going to close. I'll just ask, is there anyone here that would like to be heard on this application?
Madam Chair, may I help the board with a little something here? It seemed to me that the applicant's argument is based on two things. One is the sense of fairness of what apparently happened in the past. And then the second thing is based on the merits of what does it mean to get a lower parking requirement. I think it would be useful for the board to know that the concept that the town uses dates back to the 1960s. At that time, there were studies that basically indicated the bigger the shopping center, the lower the parking requirement should be per square foot. Since that time, pretty consistently since the mid-1980s, various studies say that the parking requirement doesn't really change. It's not really a function of the size of the center. However, the parking requirement tends to be about 1 space per 180 square feet. That doesn't work all the time. It tends to work except for about the 30 busiest hours per year. And I kind of think if you look at the Smith Haven Mall, you can probably find quite a few hours per year, usually around November, December, where it's not working. So just to let you know that the generally accepted norm is 5.5 spaces per 1,000.
Go ahead.
Mr. Tramarko, could you tell us what the consequences to Condon would be of an interpretation of 1 space per 100?
If Condon ever wanted to make an application for a restaurant on the site or any use, we're stuck with the 1 per 100. And as you can see, the last decision, I don't think you were here, Mr. Gardula, on that decision. But, I mean, the number is if I came here with a straight face in a different situation and said I wanted a 300-plus car variance, I don't think this board would in a minute grant it. But I think the board granted it because they knew in their collective hearts that it's really 1 to 166. And, you know, I don't know why the 1 to 100 was, you know, even approached, except what Paul Bregman says, because we had to do it because that's what Frank wanted, or we would be, you know, held up. We would have had to bring a lawsuit just to have him to take the application. And we have customers, tenants that have to get in. So we took the better part of valor. At that time was discretion. I did make the case at that time. I think somebody said, I think it was Mr. Benz that said he thought we made a pretty good case. I think we made a damn good case tonight. And I asked the board to help us out in this situation, because every time we come to, I don't know how many times Condon will come before this board, but every time we'll be asking for a ridiculous variance, and it doesn't make any sense.
However, Mr. Tramarko, if you are going to expand that shopping center, like you came in before, putting a restaurant or a pad, you'd have to come back to this board.
Absolutely.
Right. So he would have to come back if they're going to expand.
So your answer is it would hinder future expansion, most of all.
I'm sorry?
So you're saying that it would hinder future expansion most of all?
Well, it may or it may not. I don't know. And Mr. Bregman reminds me again that we wouldn't have given away that property on Alexander Avenue without consideration. We did get consideration, and this is what the board has to recognize. The consideration was the 1-to-166. That was part of the deal at the time, and it was a good deal for everybody. Thank you.
Thank you. All right, I'll entertain a motion to close the hearing.
So moved. Second.
It's already moved in second. All in favor?
Aye.
Aye. Motion carried. Do me a favor? Ask her, the gentleman is still waiting.
But it's up to you, Madam Chair, if you want to just have them bring one in tomorrow, you could.
Okay. Come up, please. Okay.
No, not really. It's not in the proper
Yeah, go
form.
back to-
You-
yeah.
You could, I mean, you could pick one up in any legal stationery store, and it's a lot lengthier, and the signature is different. There's more requirements to it.
All right. So
But it's up
this
to
is-
the chairwoman how she wants to
All right.
proceed.
What I'm going to ask you to do, since we heard the hearing, I'm going to ask you tomorrow to go get the legal power of attorney form, fill it out, okay, have it notarized tomorrow, if you can, and bring it to the planning department. Okay?
It'll take a day because
Okay.
Corporate headquarters are in Utah.
Oh. Okay.
Okay?
Yep.
Thank
All
you
right.
very much.
You're very
Appreciate it.
welcome. Okay. Are you back with us? Okay. Next case is case 16409, Anthony and Mary Jane Catrone, 8 Bridal Court, Fort Salonga location, south side of Bridal Court, south of Padlock Drive, Fort Salonga, property zone R21. Request variance to reduce the minimum distance to existing pool from 10 feet to 6 for an existing 317 square foot sunroom.
Madam Chairman, members of the board, my name is Vincent Tramarko. I represent the applicant. I have offices at 1038 West Jericho Turnpike, Smithtown, New York. If you look at the survey that's been provided, and I think you have pictures there, the extension is 6 feet away from the edge of the pool as opposed to the required 10 feet. There is ample walkway between the pool and the extension. I guess they call that a sunroom. And also, I think one of the reasons why the 10 feet ordinance was promulgated was, I guess, part of the reason was there was a fear that maybe kids would get on the roof and jump into the pool. But as you can see, it would be very difficult for anybody to do that. It's a gable end roof, and I don't know how anybody could even stand on it and jump in it. But the application does not have, or it doesn't make a change in the character of the area. It's in the back. Nobody can see it. Whether the applicant can achieve this by some other method, well, everything's in place. You know, permit and the CO were granted for the pool. Whether the area variance is substantial, well, it's from 10 feet to 6 feet. There's certainly ample walkway around it. It's not like the one I think I had, I can't remember the name now, where there was 3 feet between the pool and the sunroom, and you granted that. And whether the proposal will have an impact on the environment, obviously not. And whether the alleged difficulty was self-created, well, yep, they did it, and they shouldn't have. They should have gotten a variance at the time. They did not. That's why we're here today. I did go before the planning board on a couple of other matters. This is property backs up on Pulaski Road, and there was a scenic easement, which we violated in part, but we gave back property on the westerly side and the planning board said, okay, as long as you give us back scenic area approximately 320 square feet. So the planning board, not that it has jurisdiction over this, but saw fit to allow them to place the scenic easement in a different spot because there's a portion of a basketball court that invades that scenic easement. So we asked the board for its favorable consideration. If you have any questions, I'd be happy to answer them.
Okay, so I just want to put on the record that the 2 cages and the shed are going to be removed.
Yes.
Okay, thank you. Planning? Gentlemen? Okay. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second.
Really moved and second. All in favor?
Aye.
Aye. Opposed? Motion carried. Okay. Next case is case 16410. Peter Staffer, 7 Ridge Road, Fort Salonga location, north side of Ridge Road, east of Glenview Avenue, Fort Salonga. Property zone R21. Request variance to reduce the minimum side yard from 16 feet to 9, 6 feet existing, and total side yard from 34 feet to 25 feet, 22 existing, for an existing deck and hot tub. And your name, please.
My name is Peter Stauffer.
And your address, Peter.
83 Lakeview Drive in Kings Park, and I'm here to talk about this variance for my property at 7 Ridge Road in Northport, Fort Salonga.
Raise your right hand first, though. Do you swear to tell the whole truth and nothing but the truth?
I do.
Okay. So you are the owner of this property?
I am.
Okay. Want to tell us why you're here, please?
Good evening, Madam Chair and members of the board. I'm here to ask for your kind consideration of a admittedly self-created problem. It concerns a small deck that surrounds a hot tub. There's a garage that has been granted a variance, and that is 6 feet from the property line. This deck is in excess of 6 feet from the property line. I believe it's 9 feet from the property line, and so it's greater than the existing minimum side yard, and it's greater than the existing total side yard that has been granted for us in the past. There's no environmental impact. There's no negative impact on the neighbors, and no objections from any of the neighbors. It does not change the character of the neighborhood, and it fits well within the neighborhood and the backyard landscaping. So in closing, I would kindly ask the board for a favorable consideration.
Let me ask you, the garage has a CO?
Absolutely.
Okay. Thank you.
And so does the pool.
I don't want to. Died. Thank you.
Thank you.
Okay. Planning?
Nothing, thank you.
Okay. Thanks so much. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Barely moved and second. All in favor?
Aye.
Opposed? Motion carried. Next case is case 16411. Sean and Sherry Lehman, 27 Columbine Lane, Kings Park. Location south side of Columbine Lane, west of Cactus Lanes, Kings Park, property zone R10. Request variance to reduce the minimum rear yard from 50 feet to 40 for a proposed 46 square foot addition and a 243 square foot porch. And your name, please.
Sean Lehman. I reside at 27 Columbine Lane in Kings Park.
Raise your right hand, please. You swear to tell the whole truth and nothing but the truth.
I do.
Thank you. Would you like this gentleman to speak for you?
Yes, please.
Thanks. May I have your name, please?
Sure. My name is Robert O'Shea. I'm an architect at 821 West Jericho Turnpike in Smithtown.
Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Thank you so much. Want to tell us why you're here, please?
Sure. We are proposing two one-story additions, both of which will require rear yard setback variances. Number one is an 18-foot 8 by 13-foot roofed patio, which is at 40.6 feet from the rear property line rather than the required 50. The second is a 10-foot 8-inch wide by 4-foot 4 kitchen addition that leaves 49 feet rear yard setback rather than the 50. The kitchen addition that we're proposing will be built out just far enough to allow for the placement of a 36-inch wide door in the wall extending out from the existing rear wall of the house out into the yard. The roofed patio that we're proposing is being put up to provide much needed shade in this rear yard, which is fully exposed to the southern sky. It's quite oppressive in the summertime. There will be completely open sides on this, no enclosures of any kind. So, and I would like to point out, this is the portion of the project that requires the greatest relaxation of the setback requirements. This is an interesting application. It's like a perfect illustration of a little quirk that is in the zoning ordinance that probably should be addressed by the town board. But we find ourselves in a position where we're proposing a 13-foot tall roofed patio, which is essentially a gazebo, which is attached to the house. But since it's attached to the house, it's considered part of the principal building, thus requiring the 50-foot rear yard setback. In an R10 zone, you're permitted to build a 15-foot tall gazebo, or any accessory structure for that matter, within 6 feet of a rear property line. So the peculiarity here is that our application requires a zoning variance where these more imposing structures would be the property owners as a matter of right. It would just be permitted. As far as our questions up here, the variance would not propose an impact on any adjacent properties because the nature and character, the size and scale of the general appearance of the completed project will be in keeping with the neighborhood of the character of the neighborhood in general. We do not feel it is a substantial request since the kitchen addition is only 1 foot encroachment into the required yard, and the roofed patio that I described is more similar to a gazebo than it would be an enclosed addition to a house. The benefit certainly can't be achieved by another method because the kitchen exists in the rear of the house, and that is the only area available to extend it. The variance would not cause any adverse impact on the environment because it's not located in any of the mapped environmentally sensitive areas here in the town. And the difficulty was not self-created since nothing has been started yet, and the size, the location of the house was determined by the original developer of the property. I would like to submit 13 consent letters. We have 13 out of the 25 property owners that were required to be notified. I'd like to submit those. And the letter reads, I, being a resident of Kings Park and an owner of property within 200 feet of 27 Columbine Lane, have seen and understand the plans for which a zoning variance is being sought, and hereby encourage the board to vote in favor of the application.
Thank you.
That will pretty well sum up our presentation. If the board has any questions, I'll answer them as
Planning?
best as I can.
Thank you, Madam Chair.
Gentlemen? Nope, good, thank you.
Okay, thank you very much.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Going moved in second. All in favor?
Aye.
Aye. Motion carried. Case 1-15880, General Properties, has been adjourned to May 10th. Case 1-16200, Vendetta Vita and Mary Apolaro, has been adjourned to May 24th. Case 1-16355, Margaret Cheshire, case has been adjourned to May 24th. And case 16391, Brian and Elizabeth Robinson, has been adjourned to May 24th. Okay. And that concludes our hearings for tonight. Thank you so much.